Is the Marijuana Regulation and Taxation Act retroactive? To find out, you have to read People versus Pastrana, but it's 13 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Pastrana. The citation for this case is 2023, New York Slip Opinion 05966, published by the New York Court of Appeals on November 21st of 2023. The issue in this case is whether the Marijuana Regulation and Taxation Act is retroactive in effect. I'll explain what that means and the impact of that in a few moments. The background to help understand and appreciate the context of this case is, first of all, the Marijuana Regulation and Taxation Act, which became effective on March 31st of 2021, changed the approach that the police and the law enforcement can take with respect to marijuana, to cannabis. So it added a statute, which is Penal Law Section 22205. There were actually several things it did, but the relevant part for this case is it added 22205, which makes it not illegal to possess marijuana or cannabis of 3 ounces or less, and other things as well. But in addition, it says that the odor of cannabis or burnt cannabis, or the possession of cannabis in limited amounts, shall not be the basis for a finding or determination of reasonable cause to believe that a crime has been committed. Before this statute, before the Marijuana Regulation and Taxation Act, it was the basis for a finding of reasonable cause to believe that a crime was committed because it was a crime to possess marijuana in even limited amounts. The other things you have to know to appreciate the parts of this case is that, in general, the Fourth Amendment prohibits searches and seizures absent a warrant issued by a neutral magistrate upon a finding of probable cause. But there are a bunch of different exceptions to that warrant requirement. So even though it's presumptively unreasonable to search without a warrant, there are a lot of exceptions, including a roadblock. A roadblock or checkpoint stop is an exception to the warrant requirement. The police can utilize a roadblock, but they can't do it for general crime control. They can't do it to investigate if people are committing crimes. They can do it for general road safety, for license insurance checks, for things like that. But they can't do it for crime control. And the last thing you have to know is that one of the exceptions to the Fourth Amendment is plain view or plain smell. So if the police officer that approaches your car smells marijuana or sees marijuana in your vehicle, and they have a lawful right to be there, then that provides an exception to the warrant requirement, and they can seize the marijuana which is observed. Okay, what are the facts in this case? The facts are that in June of 2015, the defendant was driving his vehicle in Manhattan, approaching a bridge that goes to the Bronx. And as he approached the bridge, the police had actually set up a roadblock on that bridge, and their procedure, their neutral procedure, which they have to have for the roadblock to be valid, is that they would check every third car. So car goes, car stops. Car goes, car stops. So the defendant was pulled over out of the line of traffic pursuant to this roadblock, every third car procedure. And when the detective approached the car, he asked the defendant to roll down his window, and the detective immediately smelled the odor of marijuana. And he looked in the window, and he saw marijuana in the front of the car, like on the seat of the car, in plain view is what's said in the decision. It was illegal at the time, so the officer, seizes the defendant, pulls him out, seizes the marijuana, and searches the car and finds a large quantity of marijuana and a loaded firearm in the glove box. The defendant is prosecuted for the possession of marijuana and the possession of a firearm, and he's convicted of those misdemeanors and felonies. Before he's convicted, he has a suppression hearing, and the people establish at the suppression hearing to the satisfaction of the judge that this was a valid roadblock and a valid search and seizure. Subsequent to his conviction, they passed this Marijuana Regulation and Taxation Act, the MRTA, 5 years afterwards. So that law was not in effect when the search took place, when the seizure took place, when the conviction took place. It was in effect afterwards. And he then appealed. He appealed his conviction. Amongst the reasons he appealed, he said the suppression was bad, the roadblock was bad, but this violated the Marijuana Regulation and Taxation Act. It goes to the appellate division. They affirm the conviction. It goes to the Court of Appeals on the second appeal. And there's 3 things that are being dealt with here. Well, there's 2 things. There's the roadblock suppression issue, and then there's the validity of the the plain view and plain smell of the marijuana, and whether that MRTA is retroactive. Should it invalidate? If going forward, obviously, if the officer observed a small quantity of marijuana or smelled marijuana, it wouldn't provide reasonable cause to believe. But is it retroactive? Does it invalidate the search that already took place, the arrest that already took place, the conviction that already took place? Would it suppress the gun that was recovered as a result of that search? Okay. As to the roadblock, the Court of Appeals says valid. They go through the fact that it's done with a uniform procedure, with little discretion to the operating officers. The primary purpose is roadway safety, not general crime prevention. And they say valid. And then they go to the search and seizure. As to the roadblock, they say, they say it's valid. As to the search and seizure issue, they say here, at the time, the odor of marijuana and the visible marijuana observed was sufficient to raise it to reasonable cause to believe a crime is being committed. That was valid. The question is it retroactive? And on that, they go through the general rule, which is that retroactivity of statutes is not preferred. It's preferred that changing a statute is prospective. It goes forward. It doesn't go backward. It's not retrospective. So unless there's statutory authority or suggesting or requiring that it be applied going backwards, it's not going to be. And here, there's none of that language. So they say that the search was valid. The officer was in a fair place when he observed it. It's not unconstitutional. Conviction affirmed. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.